Ms. Missy, let me start by correcting myself before you address us. I gave instructions very early this morning that a directive be sent out that in the event that a postponement is not granted, I direct that only 30 minutes of argument will be allocated. I referred to a postponement because of an erroneous recollection of the contents of the letter that Ms. Hassim has just referred to. My memory, which was a lapse, was of the view that that same letter also sought a postponement. My co-commissioners this morning corrected me and said the letter does not seek a postponement. So I thought I should, in case my directive created confusion, just correct myself up front. But I must say this, if we get to the point where the application has to be argued, my directive as to time allocation stands. Let's hear you.
Thank you, Chair. I've considered how I would address the Commission with regards to this, and I deem it important to refer to a folktale that I've often heard in the corporate world. And the story goes that a security guard was once informed that the boss or the CEO of the company has given instructions that before 6 a.m., no one ought to enter the building. And the said CEO, on another day, attempts to enter the building before 6 a.m. And what he's told by the security guard is that, boss, umthetha uvumi. You will not enter here. I was told that you do not enter before 6. It does not matter whether you are the CEO or you are the one that gave the rule. I will not open for you. And I proceed with that because I want the Commission to get a proper understanding upon which the entire team of Mr. Matlala labors under. Correct. One would note, as correctly put before the Commission by Ms. Adila Hassim, that we did endeavor to provide them with an unsigned affidavit 45 minutes late. That's correct. It then took us approximately 3 hours to file our subsequent signed affidavit. Logically, as an individual, a layperson sitting anywhere would wonder to themselves, but if you had an unsigned affidavit and you only needed for your client to consult, make whatever changes you needed to make, why would it possibly take you 3 hours for you to then get a signed affidavit that's commissioned and file it and serve it on the evidence leaders? And that should give you a picture of how difficult it is for you to get access onto the premises, to get driven from your entrance as a visitor all the way into CMEX. When you enter the entrance at CMEX, how long you have to wait to get searched to complete the forms for you to then get taken from that point and walk into CMEX, where you also at that point have to wait for somebody to come and take you up to the boardroom that we have fortunately been allocated by management within CMEX. You then are in there, you're not allowed to have your cell phone devices, which in this day and age, that's what we primarily depend on to get access to the internet. With that being said, we would then have to go through the affidavit. You go through the affidavit, you make the changes. You now have to call said individual to come back and to take you guys downstairs for somebody to open the door for you to get out. You are not allowed, and I actually have got a tongue lashing personally by the management of security at CMEX, informing me that I do not understand and cannot comprehend the level of security and risk that I'm putting myself under by wanting to roam around the CMEX prison without somebody there to guard me and to accompany me. I then was taken to another office where I had to wait for somebody to come and take me to walk out to and go to the security with my learned friend, my instructing attorney rather. We then waited approximately 30 minutes to get a ride from CMEX all the way to the gate. We would be able to get access to our phones, get the internet, and for us to then, I apologize for that, and for him to then go and print the affidavit and then come back. That is a process on its own. We then have to start again, request for us to get a pickup to go back to CMAX, follow the whole process, somebody to pick us up, as I had explained initially. And that on its own tells you the difficulty under which we have to labor to get an act that would ordinarily take plus minus 35 minutes to get done. But it took us almost double the time. Over and above that, we did indicate to the evidence leaders that we had an issue because our lead counsel, Ms. Van Hever, was the one who was scheduled to go and consult with Mr. Matlala. So on the way there, when they had received the replying affidavit, she was unable to consult. She turned back home. And by the time we were able to speak to her, I couldn't go back in. I'm then further instructed by I'm told by my instructing attorney that even when he arrived, he was not allowed to go and consult where we were allocated to consult previously. He was treated as an ordinary visitor. So all he could do was hand over to Mr. Matlala the answering affidavit rather, and explain to him his understanding of the legal issues and the position that we would take going forward. Mr. Matlala then gave him instructions that he would need to read the replying affidavit and he wants to consider the limited advice that he has received from the instructing attorney, and that he also wants to hear the position that is being taken by us as counsel. And again, you note, we don't have cell phone devices. He does not have access, rather, to a computer where we could possibly send him an email and maybe in the evening he could quickly just see what it is that we've said, and maybe then, before we arrive, he would have a position and we could proceed. On Sunday, Ms. Van Hever then gives me instructions to go with our instructing attorney to attend to this consultation with Mr. Matlala. I personally attended to it. I had to grovel with the head of security and beg for him to at least give us 5 minutes to engage with Mr. Matlala so that we would be able to at least give him an idea where we stand, and then hopefully we can get some instructions. Over and above that, while we're at the prison, we then receive another affidavit from the evidence leaders, which they intend on using. That same affidavit I had to quickly give to Mr. Matlala to glance through. He didn't even get an opportunity to read it and to give us a position, and we do believe that he has to address it in the replying affidavits at minimum.
Is that other affidavit the one deposed to by the senior investigator, Mr. Dlamini?
That's correct, Chair. That's correct. And so with that being said, the limited time that we had while trying to balance getting information from Mr. Matlala and maintain relationships with the individuals that tomorrow we have to come back again and beg on a Sunday if necessary to give us access to him. We then had to respect the time that they had given us, quickly give him what we gave him, have him glance through the affidavit, at which myself, personally, I had not read through, and I couldn't even give him an idea of exactly what is being said in the affidavit, except to say it was from the lead investigator and it has to do with a consultation that they heard on an earlier encounter with the evidence leaders, I believe. With that being said, we were unable to get instructions from him. The little information that we got required us to then create a strategy of how we'll move forward and still be efficient. And our conclusion was that the best way to move forward would be for the instructing attorney to go through the docket again, go through the Section 204 affidavit so that he can adequately provide evidence before, rather depose to an affidavit that is correct and properly represents Mr. Matlala. We have not been able to conclude that process, and as a result, we were unable to file our replying affidavit as we had intended to on Sunday, Chair. With that being said, from Saturday, Ms. Van Hever has been sick. And I do believe in her first appearance on behalf of Mr. Matlala, at some point she intimated that she suffers from rheumatoid arthritis. That has put her in a position where she's so ill. I was engaging with her this morning. She can't use her hands or feet. She's with the doctor and they're consulting to see a way forward. But what she did guarantee me is that hopefully with the medication that she's receiving, by the afternoon, she'll be in a proper position where she'll be able to continue with us working and appear tomorrow to argue. So my instructions right now, having considered the fact that we are constantly being hit with umthetho awuvumi, you cannot do this or that, and we have to try and navigate the systems where ordinarily a layperson not sitting in this commission would think, well, these individuals are incompetent, or maybe perhaps they're trying to not come before this commission in good faith. That is not the position. You have to be in it to truly understand what it takes for you to properly represent Mr. Matlala, because he is not an ordinary witness that you have access to at 12 a.m. rather in the morning, or at 3 a.m. in the morning. We don't have that liberty before us. And I do know with regards to the additional bundles that we received later on. They make it even harder because he wants to read. He wants to know what's being said there so that he can give us proper instructions moving forward. He's not in a position where he feels comfortable that it would be smart and wise for him, given the status that he holds outside of the commission, to say to the commission, well, I did say let's go ahead, without considering the implications that it would have on him. And we beg this commission, humbly so, Chair, to consider all the elements that we consistently have to deal with to try and ensure that we represent Mr. Matlala, and also stand before the commission in good faith, that we're given an opportunity to file that replying affidavit, our heads of argument, and as well as a written condemnation application for the late filing. Thank you, Chair.
Thank you, Ms. Missy. Yes.
Chair, just 3 points.
May I just raise an issue, Ms. Missy? What the evidence leaders answering affidavit raises is a legal question, or rather what it raises are legal questions, 100%. So I don't understand this issue of agonizing over how, when to consult Mr. Matlala with regard to a replying affidavit. Those are legal questions which would not necessarily have required Mr. Matlala. Those are legal questions that you, as lawyers, should have been able to respond to. Truth be told, actually, there wasn't even a need for a replying affidavit. You could just have put together written submissions, and you would not have been out of time. So I have difficulties understanding the difficulties that you say you had.
Chair, yes, to the effect that it relates to legal issues. But there's also information during their consultation, as limited as it was, where it became clear to us, having had sight of the replying affidavit, that there's factual elements that need to be addressed that relates to documentation which we did not, or rather they did not have at hand when they were consulting. To say to that, we received a further document this morning from Mr. Matlala that he was unable to go and obtain from his the room or the prison cell that he's been kept in. And it speaks directly to the issues that would have to address in terms of the legal points. So there's a factual element
that's very
to it as well.
peripheral. Those issues about whether Mr. Matlala received certain documents a day or two before the hearing of his testimony, those are very peripheral issues, and they have nothing to do with the legal questions that Mr. Matlala's application raises. So I think my point stands.
Chair, I did not hear the last few words that you said.
I said I think my point stands.
Noted, Chair. Noted.
You are free to respond. I'm not a dictator.
No, Chair, I believe what I've set down in terms of the entire process and how we found ourselves here today I can't explain it any further than what I already have, Chair. And as I stated earlier on, I can only beg this commission to take into consideration and to give us a chance up until
I'm
tomorrow
listening. You
morning,
may
Chair.
continue.
Thank you, Chair.
Let me indicate what my inclination is, which you would obviously have seen in the directive that I issued In fact, I sent it out to the attorneys after 6 a.m. I don't know what time they instructing them to write a letter to Mr. Matlala's attorneys. I don't know what time that email was sent, but I gave the instruction after 6 a.m. My inclination is for Mr. Matlala's application to be argued now, this morning. That's my inclination. What's your response to that?
Chair, my application for a standout from tomorrow, still, that is the position that we're taking. If the chairperson could grant us that opportunity to come before this commission prepared, and at least for you to have sight on paper, at minimum, some of the case laws, because we do believe that this is an issue that has never been dealt with by any commission in South Africa. Speaking to the position that we find Mr. Matlala in, and we do deem it imperative that you have sides, yes, of the legal argument, but also the case law that we rely on to make out this argument. I don't know how efficient it will be, given that it's a constitutional issue and the position that we find ourselves in, and we've tried to look and research to see internationally if we could find something that could give us guidance on this here, on the issue that we intend on arguing. And we do believe that it would be of a benefit to the Commission to have sight of the case law and our written submissions, Chair. I don't know how beneficial it would be if I only argue this and you are unable to make reference to those cases and the paragraphs and see exactly, is she applying herself correctly? Do you agree with me, yes or no, and what's the position? And I think perhaps that's the consideration you'd have to make in finality, which is one, this is a position that we believe any commission here in South Africa has never had to deal with and answer and consider, and perhaps it would be beneficial to have consideration of the cases that we would like to refer to or refer the commission to, Chair. Thank you.
Thank you. I will go back to the question that I asked about this being a legal question. This is something that Ms. Vandenheefer was quite passionate about from the day of the last appearance. She referred a number of times to an application where points in limine would be raised. From the moment that you start thinking about bringing an application in which you are going to raise points in limine, you already know what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. Vandenheefer, Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this the process that we have before us this morning, and underlined, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making, that perhaps what we could have done in the interim was prepare the heads of arguments to assist the commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight, and that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.